All attendees are in listen-only mode.
Hello, everyone, and welcome to the webinar on CalFresh verification, hosted by the Alliance to Transform CalFresh. Today we'll be covering a couple of aspects of verification. First, a new rule related to the work number, which is an electronic verification tool used by county eligibility workers. And then we'll talk about opportunities to maximize the use of deductions while also reducing verification burden. As usual, you can send in questions via the toolbar on the right-hand side of your screen, and we'll cover those at the end of the webinar. We'll also be recording this webinar, and we'll be sharing it on our website. And for those of you that have registered, you'll also receive the recorded webinar in an email within the next few days. Before we start, I want to highlight a little bit about the Alliance. So Sarah, can you move me to the next slide? The Alliance to Transform CalFresh works to raise the rate of CalFresh participation overall in the state of California and have no county below 70% in the next couple of years. We focus on 4 data-driven strategies that include same-day service, reducing churn, dual enrollment, and equitable access for all. Today we're focusing on quick access from our HTC strategies, ensuring verification options are utilized effectively, that clients' rights are protected, and reducing burden to clients and counties is a way to move towards same-day service and the reduction of hunger for California's food insecure families and individuals. Next slide. For today's webinar, we have a really great panel of presenters joining us. First, we're going to talk about the new legislation related to the work number and electronic verification databases. Alexis from CDSS will be speaking first, and then Jessica from the Western Center on Law and Poverty. Then we're going to talk about deductions and reducing verification burden. We'll have Ed from the Center on Budget and Policy Priorities, Randy from San Francisco County, who's going to talk about the deskies that they created. And then Jessica will close our presentation with more information about verifications and avoiding over-verification. At the end, we'll wrap up with a few minutes of questions. So let's get started. Alexis Fernandez, you're up first.
All right, Jennifer, thank you so much. Can you hear me?
Yes.
Great. So good afternoon, everyone. Again, this is Alexis Fernandez, and I'm the Chief of the CalFresh Policy Section here at the Department of Social Services. And today I'm going to talk a little bit about recent changes that resulted from Senate Bill 1232. I'm going to go into a little bit of detail about what the recent all-county letter provided in terms of guidance on this issue. And then we'll talk a little bit about consumer credit agencies and the work number specifically and how we as a department are viewing their use. So SB 1232 established protections regarding consumer credit reports for CalWorks and CalFresh clients. And you can find the all-county letter is 16-118, so you can find a lot of this information there, and we can share the link with the group after the webinar for that letter. The protections that were established include obtaining client authorization prior to using a third-party consumer credit agency or information provided by a third-party consumer credit agency, providing notice to clients when that usage results in an adverse action, and specifies that county welfare departments shall not request duplicate documentation from the client if the information is obtained via a consumer credit report. So I'm going to go through those step by step. On the piece regarding client authorization, this authorization is obtained via the SAWS 2 Plus multi-program application, as well as through the CF 285 CalFresh only application and the CF 37 CalFresh only recertification form. So we've updated these forms accordingly to provide clients information around the potential use of the consumer credit report and ensuring that we have their authorization before using the consumer credit report. CDSS has also developed an informing notice that must be used when an existing notice of action is provided to a client. So this provides clients notice that a consumer credit report result was used and led to an adverse action. So the notice informs the client that a consumer credit report was used, provides information about the specific consumer credit agency, such as contact info, and lets the client know how they can go about getting a copy of the report and correcting any misinformation that might have been contained in the report. So this is really an informing notice that kind of gives clients an overview of what their rights are and how they can go about getting more information or correcting a report. Lastly, with regards to duplicate documentation, the ACL specifies that the County Welfare Department will not ask a client to submit documentation that is duplicative of the information already obtained in the Consumer Credit Report. So, for example, if the Consumer Credit Report is used to verify incomes, in the case of the work number, we would not ask the client to bring in a wage stub to doubly provide the verification for something we've already verified. An important note here is if the client disagrees with the information provided in the work number or the Consumer Credit Agency report, they have the right to contact the credit agency and correct that information, but we still need to make sure we have adequate verification in order to determine eligibility. So we would work with the client to secure the right verification so that we can move forward with an eligibility determination. So in addition to All-County Letter 16118, which talked about SB 1232, we also issued an All-County Letter 16-43, released in May of 2016, which provides counties with detailed information regarding work number services specifically that are available to them. So the work number is an example of a consumer credit agency such as those referenced in regards to 1232, and the work number provides instant employment verification data such as employee earnings and hours worked by utilizing the participant's SSN. The work number may be used for verification purposes in both CalWorks and CalFresh. It can be used for initial and ongoing eligibility in conjunction with, not in lieu of, existing required income and eligibility sources. So really very popular on the CalWorks side. It was used for a while and now has been expanded for CalFresh purposes as an additional verification tool. As we continue our efforts toward expanding same-day service and generally reducing the time it takes to process an application, we consider the work number a verification tool available to counties to make you eligible today. That is, if an applicant walks in the door and is missing necessary income verifications, an eligibility worker could reference the work number and use the information available for purposes of determining eligibility right then and there, versus waiting for verifications to be submitted by the client or using other means to verify income. So we do think it's a useful tool to help clients kind of get the verifications they need for a quick eligibility determination. And I am going to actually stop there and will be available to take questions at the end of the webinar.
Great, and I think that queues me up for my turn. If you could please advance, this is Jessica Bartholow from the Western Center on Mom-Poverty. If you could please advance the slide to my slide, that'd be great. And so you see who I am, and now to the and to the slide with the link to the first ACL. So first and foremost, I just want to thank Alexis and her team there at the CalFresh unit of the Department of Social Services for their diligence on this issue and implementing this legislation. They've done a great job, and I really applaud them for a really kind of perfect implementation of this policy. To give people a sense of how many people are impacted by the policy, I think it's important for people to know that approximately 40%, an estimated 40% of America's workforce has a file in the work number. Again, this is the work number is a database, a specialty consumer report that is owned and operated by Equifax, one of the 3 main consumer credit reporting agencies. A lot of people are in the database and don't know they're in the database. They are supposed to have approved their files from their employer to go to the database, but we find that sometimes that doesn't happen, or it happens, kind of with all the paperwork that you sign when you're employed, and so they don't know. I say this because While moving forward from here on, the notices will have information about negative actions taken, and if they are taken, and people will have the ability to sign. When they sign their application, they'll be giving authority for the Department of Social Services and the county agencies to inquire about their work number file. We still have many years in which the work number was used in California, and people's files accessed, and they might not know that an overissuance they received in the program resulted from an inquiry in that file. So as you're working with people who are coming to you perhaps with requests for assistance on overissuance, whether you're a county worker or you're an application assister or you're a legal services provider, we are encouraging people to make sure and ask the question about the overissuance. The notices, the state is working with advocates and counties to update and improve the notices of overissuance in the CalFresh program so that they're more descriptive of the type of overissuance you have and what caused the overissuance, and if it was for income, whose income was being considered in determining the overissuance. But there's still a lot to be worked out in that process, and so it's not always clear if the income that caused the overissuance actually happened, was actually caused by that household. So as you're working with people who have overissuances, please ask about whether or not, if it's not clear on the notice, ask for clarification on which income created the overissuance, and check with the recipient or the former recipient to make sure it makes sense to them. We have had cases come through legal services and to Western Center in which the work number had an error, and the people were facing fraud charges as a result of the error. So this is just me asking all of you to please look for overissuances from the past. If you see somebody with an overissuance due to income that they don't understand, it's possible because of the work number. And because of the legislation and the state's really great implementation of the legislation, people should have the right, and it should be clear that they have the right to request a copy of the work number file if they do have an overissuance. Even if you don't know that they might have one, it's important to ask for one anyway. So with that, I'll leave it there and just say, thank you again for the Department of Social Services for a really great implementation, and we look forward to updates in coming years about how it's working for upfront verification. And with that, I'll pass it back to the moderator.
Thanks, Jessica. Now we have a presentation from Ed Bolin from the Center on Budget and Policy Priorities. He's going to talk about deductions and a little bit more about the importance of making sure you explore the options for deductions with your clients.
Good afternoon, everyone. Thanks for having me on this webinar, and thanks to the Alliance for putting this together, and Alexis and her team for their work on verifications and all the other related issues that California is dealing with. My name is Ed Bolin. I'm a senior policy analyst at the Center on Budget and Policy Priorities. I'm going to come at this from a slightly different perspective, partly because I'm in DC now, and so everything's got a different perspective. But also, I want to talk a little bit about how verifications can really play a big part in influencing how many benefits some households can get. Clearly, there's a role for verification to make sure the program is run and eligible people, and only eligible people, gain access to the program, and that the calculations are correct so that people are getting the correct amount of benefits. But there's other ways that verification policy can sort of play into how states choose options, and how things like deductions can influence a household's SNAP benefit levels, sometimes significantly. So I'm going to focus on a couple of deductions. Next slide, please. Just on a quick background, as I think many of you are aware, SNAP benefits are calculated based on a formula that assumes households will have 30% of their net income for food. That's a different test than the eligibility test around gross income, but the assumption is 30% of their dollars after essential expenses are accounted for, can be spent on purchasing food. And if that 30% isn't enough to allow the family to get an adequate, nutritious diet at minimal costs, SNAP is supposed to fill the difference. And that's what the benefit represents, is enough for a household to get a minimally nutritious diet. So in order to get to net income, you start with a gross income, but you deduct certain expenses from that income. And that recognizes that most households have expenses that really do limit the amount of funds they have available to pay for food. So you can't just take a gross income and say you can spend all of that on food. Of course not. You've got to pay for shelter. You've got to pay for childcare if you're a working family. You've got to pay for medical expenses. So here's just a quick list of most of the basic SNAP deductions for states: earned income, a standard deduction, dependent care, medical expense, and shelter. Next slide, please. I want to focus on two underclaimed deductions, which are deductions that many households that are eligible for them, and they're eligible for them because they have expenses, don't claim them, and hence don't receive all of the SNAP benefit that the formula itself recognizes that they need to buy food. So next slide. The first one, the dependent care deduction. This is a deduction for expenses, as you might guess, for dependent care costs. Just a couple of notes about it. We have a lot of resources on our website, the Center on Budget's website, that describe this deduction, the next one I'll talk about, and a few others in great detail. And looking at the regs and California's ACLs and statute might help flesh out how this actually works. But just a couple of notes about the deduction that sometimes gets lost for households who may not know anything about it, but even for agencies that may be streamlining systems or updating systems and not taking into account all the different possibilities that this deduction offers, is that first of all, many kinds of care qualify. We're talking about formal child care. That's typically what people think about when they think of the dependent care deduction, but it actually can include informal child care, like a neighbor, anybody outside the household caring for a child for a household if they're working or in school or looking for work. But it also includes adult care. So a dependent adult can be expensive to care for. And if somebody, in fact, is out of the house looking for a job or in training or working, they need to pay for that care. So adult care can count as well. Summer camps can count. Before and after school care can count. There's a wide range of programs that can count for dependent care costs. And it's very unusual for state agencies to pretty comprehensively elicit that information from households. So unless the household knows about it, they're not going to offer the fact that they do have these expenses when they're applying for SNAP or recertifying for SNAP. The last note I'd make about just what the dependent care deduction is that it actually applies to any dependent up to the age of 18. So there's other programs and even other parts of SNAP that exempt people for kids under 6 or only go up to children up to 12 years of age, not the dependent care deduction, because again, it's trying to capture costs that people have for taking care of kids when they are otherwise working or in training or in looking for work. Next slide, please. So I wanted to flag what that actually means. And here's just an illustration of what some household that takes or has dependent care expenses and actually includes that in their household, what that means as far as benefits go. You can see it's in this sort of hypothetical, a significant increase in benefits. That's a monthly benefit. So over the year, that's over $1,000 in additional food assistance that a household with $250 a month in dependent care expenses has. I'd note that there's no cap in how much can be spent on dependent care expenses. Last time I was in California, child care costs $250 for like a day of child care, right? So many people could have pretty significant expenses taking care of dependents, and all of that could be deducted from their gross income. That will bring their net income down quite low, which would help them boost their SNAP benefits. Next slide, please. So here's where California lands as far as the percentage of likely eligible families that are claiming the dependent care deduction. Not the best. Less than 10%. This is from 2015. The numbers could change. Most states are actually not so good. The average is, I believe, below 20% still. There's a few states that have done a good job of making this known to households and streamlining the process to actually claim those deductions. And I think one of the places that states do that is by simplifying how those expenses can be verified. Some states have matched to other databases outside of SNAP. For instance, the child care agency may have a database of folks who receive subsidized child care. It may have a database of people who used to receive subsidized child care, and those can be matched up. Now, households can't deduct the subsidized child care, but the co-pays or any other costs and the kinds of after-school, before-school care costs that aren't covered by a subsidy could be deducted. So it's a place that some states have been able to make a match. They've also worked with programs like the Child and Adult Care Food Program, where they have providers who might be very helpful in telling households that they can submit their expenses in their application or recertification, and hence get the child care or dependent care deduction. Some states limit the verifications. States are required under the federal regulations to look to documentation, which means essentially paper information about expenses, so households' child care bill or invoice. But they're not limited to doing that, and they are supposed to help households find other ways to provide that verification, whether it's a third-party contact with the provider or some other way of getting that information. So states have moved away from documentation, putting the burden of documentation on the household, and either asked for third-party verifications or using other sources of information to supplement or replace the individual household responsibilities. Next slide. So the other deduction I wanted to very briefly touch on, which is, can be very influenced by verification policy, is the medical expense deduction. This is for seniors and people with disabilities. If households with members who are senior or disabled can claim out-of-pocket medical expenses over $35 a month, they can deduct those expenses. And again, as with the dependent care deduction, there's a wide range of expenses that can be claimed, including those not covered by health insurance. So, and that can be over-the-counter medicines. It can be hospital bills. It can be medical equipment. It can even be transportation to and from the doctor's office. And I should note for dependent care, same thing. Transportation to and from can be counted as part of the costs. So there's a wide range of things that can be deducted. For seniors and disabled people, verifying that by providing bills and payments can be a huge burden. And we know in many states that drives a lot of seniors and disabled folks from claiming the dependent care, the medical expense deduction, simply because they either don't have those, it's hard for them to carry them to their office or otherwise get them to the SNAP agency, or they're embarrassed about their medical conditions and they don't want to share that information. So states have tried to streamline that process by, again, looking for other sources of documentation aside from asking the individual to bring in paper records. They have looked carefully to make sure they're not asking for verification of unnecessary things. Like, for instance, if somebody had a medical procedure that costs money, you don't have to verify that that was a medically necessary procedure unless you have questions to wonder if it was or wasn't, which I would imagine is very rare for this population. And similarly, many of this population has pretty constant expenses, although they probably go up over time due to the rising costs of healthcare. But what they need doesn't change much. And so states don't have to ask for re-verification of unchanged expenses at recertification or when they have to file a periodic report or not. And so states that have done that have found it much easier to serve this population and more people signing up and claiming the deduction. Next slide. So I just wanted to highlight where California lands on that range of states, and almost a fifth of likely eligible households are claiming the deduction. That's great. I think all these numbers are low, these percentages are low, so we urge every state to be improving, and there's no reason that most seniors and disabled individuals are not at least asked and assisted in filing for a medical expense deduction. Next slide, please. This is just a little bit of background, and it kind of just highlights the point that depending on the particular population, and these are national numbers and national percentages, for some populations this can be a real barrier, and so the numbers of folks, for instance, SSI recipients that are claiming it is very, very low. And so I think some of the states that are trying to reach out to these populations are starting to look at what is it about particular groups that's making it harder and harder for them to claim the deduction. I want to note that some states do use standard medical deductions. I don't want to get into that now simply because we don't have enough time for it, but it's another way that states have tried to streamline the process, and I believe something California, there's conversations in California about. So I will end with the next slide, just simply to flag that there are other deductions as well. And again, we have resources and are happy to help both advocates and agencies figure out ways to make sure that these deductions, which are really critical ways to ensure that households get the amount of benefits they need to feed themselves and their families, that these deductions are fully utilized. So I'll end with that. Thank you.
Thanks, Ed. Really quickly, does the Center on Budget and Policy Parties have a comprehensive list of the things that can be claimed either in the dependent care or the medical care deduction?
We have a long list. I don't think there's such a thing as comprehensive because states have some flexibility in defining what they'll accept, and so some states will take some things and some won't. But yeah, we do have a pretty comprehensive list because some states have a very restrictive list, and that can freeze out people who have legitimate expenses. I'm happy to share that you can send around to the folks on the webinar.
Great, and maybe we'll check with Alexis and see if there's a California list that would be useful to share with our partners. Okay, great. Next up, we have Randy Mono from the San Francisco City and County Health Human Services Agency to talk about a tool that they came up with to help reduce over-verification. So we just talked a little bit about, making sure we provide sufficient verifications to maximize deductions, and now we want to not swing that pendulum too far and make sure that we only are providing as much verification as is necessary to verify that deduction. So Randy, take it away.
Thank you. Good day to everyone. My name is Randy, and I'm a CalFresh program specialist here in San Francisco County. I just want to start by kind of laying the landscape of where we were maybe a year or so ago. And we were receiving feedback from community partners, some maybe on the phone, as well as from staff that, that there are certain ways that you can simplify the process for both eligibility staff as well as for households. And many of those changes were implemented as part of semi-annual reporting. Others maybe gray zones in the regulations. And as long as it does not, detract from other efforts, such as on the quality control front, that it makes sense to implement across the county. So we undertook an effort to try to address that concern. And if you could go to the next slide. We drafted and released a memo to staff within our agency who processed CalFresh cases. And the focus of the memo was on the topic of over-verification. And so one of the overarching goals that the agency has is to increase the county's participation rate, right? And so we reasoned that, through analysis and through anecdotal evidence, that many of our applicants or clients, both here and across the state, may be feeling like even 2 verifications, 3, 1, is too much for them, that they're not going to complete the process, and they simply churn off unnecessarily. So we were trying to outline in this document what we wanted to outline what's legally required for eligibility determination, and to try to streamline the verification process across the board. And so I'll kind of walk through several of these categories, and of course take questions at the end if anyone has them. So on the first point, that at SAR 7 or at recertification, if the household does not report any change in income, and I think Ed kind of referenced that for expenses, but same holds for income, if they report the same income or expense, the EW does not need to pen the case, right? As long as they report it on that document and they verify it as part of the recertification interview, there's no legal requirement to obtain additional proof. Again, we have it in our online file system, and that would be used in a quality control review. On the second note, bank statements and tax returns. So yes, typically the household will submit a pay stub or some other income verification from the employer or source of income. But sometimes they might forget. And if they're not in the work, if that employer is not in the work number, particularly in a self-employment situation, then there are other ways that you could obtain that information, possibly through a bank statement or possibly through a tax return. But requiring a household to always submit a bank statement and tax return, even if they have provided pay stubs or affidavit about their income amount, that's excessive, right? That's over the line. So we're trying to point out that those documents, the bank statements and tax returns, are not required for CalFresh purposes. It can be used as like a supplemental data point, though, if there's like a fluctuating situation and the household isn't sure what to do in terms of filling out the document, the application or the paperwork, then we could point to something like a bank statement or tax return, say like, well, you could provide that as a verification if you're unsure what to do, and then we can use averages to try to reasonably anticipate an amount going forward. But otherwise, we wouldn't normally need those documents for CalFresh. Other programs may have their rules, but CalFresh doesn't look at resources typically for income. The third point kind of addresses what the quarterly reporting system required, which was a 10-day report of a change in address. Semi-annual reporting does not have that same requirement. So just emphasizing here that a household could be temporarily outside of the county, could be temporarily outside of the state, even the country. And that's no longer cause to require a mid-period verification or discontinuance. We can hold that change until the next required report when an address change is required, but doing any action, county-initiated action mid-period, is no longer required, so we shouldn't be going down that pathway. Next slide. Okay, so point 4 is around income verification, and what this is trying to get at is that we have access to a number of data sets, and we've talked a little bit today about the work number, but there are other data sets that eligibility staff have access to here and across the state, and that we should use those sources before pending the case. It's very easy to just, you have your number of cases that you get in the day, and it's easy to just say, well, I got to get to the next case, or we have a queue of 1 hour, so we're trying to get to the next person. But really, like, that extra minute in research may save the county a lot of time, and it saves some burden on the part of the households, and hopefully increases the likelihood of an approval of an eligible case. So we were just trying to emphasize, make sure you go through all the resources. People know this, but seeing it is just another reminder of the number of resources that a county may have access to. On the expenses front, we were trying to discourage eligibility staff for unnecessary requests for verification pending cases when it's related to an expense that's not required verification. For example, Ed pointed out medical and dependent care expenses, right, that they're underutilized. And yes, the household may report during their application or interview process that they have these expenses. But if they report it and they don't have verification of it, and we don't have any way of verifying it through our system, that's not a reason to pen the case, right? We would authorize the case without that voluntary expense, and then advise the household to submit proof of that expense, and then we could take action on the case at that time. So, so medical and dependent care expenses, also if their rent and utility expenses below total income, we don't require as a state to verify that rent or utility expense. So there's a number of ways that you could try to reduce not just the work coming into the county, but the number of verifications, expense verifications that you ask of the household. Number 6, so identity. There's a prevailing attitude, I guess, that the best way to verify identity is through a photo ID, right? Not just maybe here, but we see it in other counties, we see it in other states, that somehow this photo ID is inextricably linked to the person's identity, that you have to see that in order to know who it is that you're talking to. And we're expanding that definition to what the state has defined as identity verification, that it can be verified through a wage stub, for example, or a collateral contact, or work ID, and so forth. That it does not have to be, there does not have to be a photograph on that ID, that there are a number of examples that the state has given, and that we're permitted to, for example, approve expedited services as long as we've verified identity and they meet the income and resource requirements. Citizenship and sponsors. So we get a number of cases where there are non-citizens in the household, and sometimes there may be an expired card, and an expired LPR card, and we found that that alien number on that card can be used to do that secondary save request, or if necessary G845, to just make sure that the status of the individual, the legal status of the individual hasn't changed. But there's no reason to force the household to find a new unexpired document that shows that they still retain that legal permanent resident code. And then also point out that our online file system may include other citizenship or sponsor details because it's linked to our Medi-Cal and CalWorks and general assistance programs. So make sure to use those resources, kind of like we referenced in point number 4 about income. Wrapping up, so Social Security number, that we don't need the physical card or copy of the card, that the number is what's required, and if there's something truly questionable about it, that you can do a secondary look in meds to see if the SSN is verified. And then the last point came up through feedback from our quarterly advocacy meeting, where the advocate pointed out that the advocate partner pointed out that, you know, a number of stipends related to the Older Americans Act are exempt, and so it was a good refresher for you know, eligibility staff to put it in here and to talk about it with staff, just because it may not come up in every case, but it does come up, and we do have you know, a sizable lower income elderly population here in San Francisco, and many of them may still be working to make ends meet. So just a reminder on that. And on that final point, I'll turn it back to the moderator.
Thanks, Randy. Will this document be, I think you'll be sending a copy and we can share it with the people on the call if they'd like to implement something similar in their county?
Yes, I can email a PDF of that.
Great, thank you. And now we have Jessica back again to talk more about verifications. Thanks, Jessica.
Thank you. I hope everybody's learning as much as I am in this webinar. It's been really great to hear the other speakers. So what I want to do is just kind of round about what is happening in California with regards to some of the things you heard Ed Bowen talk about for verification. Let's start first with the state utility assistance subsidies. This is just a reminder that since our state's implementation of the 2014 Farm Bill, we are not requiring that you have the verification in hand in order to get the SUA deduction. So we haven't seen at Western Center on Poverty, we haven't seen any problems with this, but just as a reminder, and also a thank you again to the Department of Social Services and to the governor and the members of the legislature that helped make this happen, right? That helped the broadest implementation of the 2014 Farm Bill to make sure that it didn't harm low-income people when we implemented a new rule in that bill. And the ACL for that is All County Letter 1466. I want to talk about verifications of dependent care expenses. I had heard Ed Bowen give this presentation in a national meeting and was really shocked, quite frankly, to see our participation in our ability to get the dependent care expenses for our population so low. It bothers me, right? Because the very purpose of that rule is to prevent hunger in households with very young children. As a reminder that hunger in households where there is young children can result in lifelong impact on a child's ability to thrive. There's evidence that shows even one incident of hunger can reduce their lifetime opportunity. So this is, in my opinion, the information that we heard from Ed about the low receipt of this deduction is urgent, and we should be responding urgently to that situation. We did have legislation that was passed by Senator Leno. You might recognize the name again, the same author that passed the work number legislation last year, was also the author of this legislation, which in 2013 was passed and signed by the governor, which requires that dependent care expenses be allowed to be verified by self-certification of the recipient or applicant themselves. This is an option that the state of California has, that the federal government gives, that we can allow somebody to verify, not by having a receipt from their child care provider, not by having another type of document, but by self-certifying that indeed they have the cost and verifying the amount. So it seems to me that it is within our grasp. We are using that as a best practice that Ed talked about. This is something that other states have used, the self-certification of expenses, as a way to get to a higher amount of the deduction being used. But maybe we can work together as a team of CalFresh interested parties and advocates, counties, state officials to identify some strategies and some partnerships, perhaps with child care providers. You know, it was mentioned by Ed that that's a strategy that has been used, and we know that in California the child care providers are very adamant child advocates, and I've seen them in the Capitol be very supportive of efforts to reduce harm to children by making change in our public benefit programs. So I know I will commit, after having learned, you know, having gotten some advice from Ed's presentation, to approach them, and if others are interested, let me know. But let's all agree together to try to figure out how to make sure that ACL 13102 and the option to self-certify these expenses is well known, and that people in the community know that they can deduct it right off their gross income. So that's the third point, and or the second point. And then the final point I wanted to say to you, make sure that you have, is ACL 14511. This is an older ACL. When you open it up, you'll see that there are some pieces of it that are now overridden by the previous ACLs, right? So for example, the dependent care expenses, that law came after this ACL, and therefore it overrides this ACL. However, the chart itself is really helpful. At the end of the ACL, it provides a chart with all the federal guidance of Code of Federal Regulations citations regarding verification, what's optional and what's not optional, what must be received kind of in writing, and in which ways, at least pursuant to federal law. So they give us a sense of what we're required to do by federal law. I think that's really helpful for advocates to know. I know when I worked, you know, in the field on CalFresh outreach, at the time it was food stamp outreach, it really helps me to understand where rules came from, so that I could better understand and help the applicants and recipients who are, you know, who's subject to those rules. I could explain them better, and I can help them comply with those rules better. So I wanted to make sure that you had access to this ACL and the chart on it, and also, you know, let this serve as an invitation to the Department of Social Services, who I hope is still on the call, that maybe we could relook at this ACL and the chart in it, and look at updating it with the new rules. So with that, I am concluding my presentation, and I believe leaving some time for the moderator to take some questions.
Jessica? Yeah, we have a couple of questions. Sarah, do you want to read those?
Sarah, if you're speaking, we can't hear you.
I will read the question real quick. Is there any conversation at the federal level about raising or eliminating the maximum shelter deduction cap? Jessica, can you or Ed Bolin speak to that?
The short answer is no.
Well, let's both answer. You go ahead. You go ahead, Ed.
Yeah, I mean, as far as sort of the leadership discussions that we get wind of, I don't think there is much discussion about it. I mean, I think, well, and I'll let Jess answer.
Yeah.
I mean, I think there's efforts to change that, but.
Right, and so my answer would be that it's our job as advocates and people who can speak specifically about the impact of that shelter cap on people in California, especially where the cost of living is so high, that it's our job to change, you know, whether or not leadership is talking about it. And so the question as to whether or not there is conversation at the national level about removing the shelter costs, I would answer that yes, there is conversation. Have leadership joined in the conversation? Maybe not yet, but that doesn't mean that there's not conversation. So let's continue to have that dialogue. Stories about how people are impacted by that shelter cost, send them my way. We can use that. There has been legislation, you know, over the past couple of years that would have included an increase in shelter costs. There's no reason why we shouldn't continue to seek legislation to be introduced in Congress, even if it can't be passed. We all know here in California as advocates that sometimes it takes a long time to talk about something, to raise an issue, and work in coalition to change the mind of people in power, and who could make the votes happen. And so let's continue to have the dialogue and make sure that it is a national conversation about increasing that cap.
A follow-up question, Jessica, is there any conversation at the state level about eliminating the cap?
Without a change in federal law, it would be hard to do because it is a federal rule. I suppose we could somehow accommodate it in the same way that we do the WINS, the Special Nutrition Incentive Program, the work incentive programs that people know adds an additional $40 to CalFresh benefits for families that are working. Perhaps we could think about a state-only benefit that would accommodate families with a state general share benefit that, you know, when they had higher cost of living. I hadn't thought about it, but it's not a bad idea. And I'd like to continue the dialogue before the next legislative session.
Great, thank you. Other question, Alexis, can you confirm, have the updated forms related to the work number and the requirements for client permission, have those been shared with counties, and should they be implemented at this time?
Yes, so we've updated all the forms with the required language, and the newest version of the application, both CalFresh only and multi-program, that is out in the world should have the authorization language, and it should be implemented. Of course, one of the caveats is you can imagine someone might be using an old printed version. So we've really encouraged our counties to use the new version moving forward. But it could be, you know, a CBO partner, or even counties shared a random pile of applications from before the change came into place. So just that caveat.
Great, thanks. I don't see any other questions from the audience. If there are future questions, we will be sharing the webinar and the contact information for our presenters. We will also be sending out some information about the deductions and links to the ACLs that were mentioned by the presenters. Thank you so much to our presenters today for your knowledge and for the information that you shared. And you can find more information at transformcalfresh.org. We have all of the webinars that the Alliance has hosted in the past 5 or 6 years. We also have a number of blog posts with updates about pieces of legislation that are being implemented and other updates. So feel free to check out more information there related to the CalFresh program. Thank you, everyone. Have a great day.